Hello everyone. Welcome to the first video of Law of Contracts of 1872. Before I get into discussing what this video contains, I have one simple question to ask. What is a contract? So in very simple terms, a contract is a legal obligation that binds two or more people into performing or to not perform certain actions. Now discussing about what the video contains. This video contains a few basics of law of contracts, little history, and then coming up till section 4 of this act. Coming to the history of this law of contracts, sorry. Before 1872, law of contracts in India were regulated by English common law and by different religious laws, which created various inconsistencies in practicing law. Contract Act in India came into force on 1st September 1872 and it applies to all over India except for Jammu and Kashmir. This is something I would want you to note is that section 28 to 2J of this act contain definitions that are going to be followed by the rest of the sections. So do not take an easy way out of it and please do learn all the sections, which will make it easier for you to understand the rest of the 75 sections. Coming to section 3 of this act, section 3 very plainly in bookish language states that the communication of a proposal, the acceptance of a proposal, and the revocation of a proposal and acceptances, respectively, are deemed to be made by any act or omission of the party proposing, accepting, or revoking by which he intends to communicate such proposal, acceptance, or revocation, or which has the effect of the same. In simple terms, this section covers proposals and acceptances and how it is communicated between two or more parties depending on how many people you're making the contract with. So for a simple example, for better understanding, X offered 3 lakh rupees to Y to buy his house. This here is a proposal. X has made a proposal to Y, and when Y agrees to it, there will be a contract between X and Y. Coming to section 4 of this act, section 4 states that the communication of a proposal is complete when it comes to the knowledge of the person to whom it has been made. Again, in simple terms, it talks about when a communication is complete. Say, for example, when X gave the proposal to Y, the communication there is complete. Now, the obligation is shifted on Y, whether or not he wants to agree to his terms or to make the contract or not. So this is something I want to additionally also tell, that I'll be teaching a few sections in pairs, a few sections individually, so that it's easier to understand. So there are mainly 4 types of proposals that get covered into these 2 sections. The first is expressed, second is implied, third specific, and fourth general. Coming to express proposal is when the parties lay out their obligations explicitly or they lay out the terms of the contract explicitly, and it's either orally or in writing. Okay, and all of the parties are in agreement in the common sense. Coming to implied is legally binding based on the actions of the person involved. For example, all of us over here would have gone to a restaurant, and our act of sitting down at a seat over there gives the waitress or the shop owner the idea that we are ready to order. This is an implied contract between the two of us. Our actions showed the other person that we want to get into a contract with them. The third one, specific proposals. This proposal, as the term states, is for a certain specific feature or for a certain specific group of people. Okay. Now coming to the last one, this is going to be interesting. The last one, I have a case law for all of you that covers the part of general contracts as well. This case law is Carlyle versus Carbolic Smoke Ball Company. So read that and come and let's discuss it in the comment section. Bye. Thank you.